Welcome to this London Shipping Law Centre webinar held in association with Quadrant Chambers. My name is Richard Saul and I'm a shipping barrister at Savin KBW. On behalf of Alika Mandaraka Shepherd and the LSLC, it's my pleasure to welcome you and to introduce tonight's chairman. The subject of this webinar is the decision of the Supreme Court in the matter of the CMA CGM Libra. There it was held that a vessel was, in breach of contract, unseaworthy because of defects in a ship's document, namely her pre-departure passage plan. Sometimes it's a fate of very important decisions that there is a fundamental disagreement whether the case breaks new ground or not. The winning party and their camp of followers will tend to say, but that was always the law. Having discussed the matter with a number of different stakeholders, it seems to me that there is that sort of fundamental disagreement in this case. Is it new or not? You decide. Personally, I found the case intriguing. I had some small involvement in it, pursuing an application to intervene on behalf of the international group, which was refused. And that explains why, as a member of London Shipping Law Centre's Education Subcommittee, I was very keen for the webinar to feature on the programme. I'm therefore delighted that one of the successful advocates, Benjamin Coffer of Quadrant Chambers, is a member of tonight's panel, taking the place of his leading counsel, John Russell, QC. No doubt Ben will be able to tell us all about it. The other speakers will be introduced by tonight's chair, Sir Nigel Teare, who was the judge at first instance in the Admiralty Court. Sir Nigel needs no introduction, but he was called to the bar in 1974 and appointed Queen's Counsel in 1991. He was also the Lloyd's Appeal Arbitrator in salvage disputes from 2000 to 2006. Until last year, he was the Admiralty Judge. He now accepts appointments as an arbitrator. I've been told to invite you all to put questions into the Q&A rather than into the chat box. And having given that introduction, it's now over to you, Sir Nigel.
Thank you very much, Richard. I suspect that many of you will be familiar with the case. In short, the case raises both the scope of the owner's obligation to exercise due diligence to ensure that the vessel is seaworthy before and at the commencement of the voyage, and the scope of the negligent navigation exception in the Hague Rules. The particular question raised by the case was whether a defective passage plan prepared by the master renders the vessel unseaworthy. The Admiralty Court, the Court of Appeal, and the Supreme Court held that it did. In the case, a notice to mariners advised that outside the buoyed channel at the port of Xiamen in China, there were depths less than those charted in the approaches to the port. Neither the vessel's passage plan nor her working chart gave notice of that danger to the navigating officer. When the vessel left the port, the master was on the bridge. He chose to leave the buoyed channel, something which he would not have done had the danger in doing so been present to his mind. The vessel grounded on an uncharted shoal, giving rise to an expensive salvage operation. It was held that the passage plan ought to have alerted the navigating officer to the no-go areas outside the buoyed channel, and that its failure to do so rendered the vessel unseaworthy. One of the issues raised by the flyer to this discussion is whether the decision of the courts was controversial. I'm aware that the decision has given rise to controversy, but as I made clear at first instance, the decision was reached by the application of well-established principles. That might suggest that the decision ought not to be controversial. It has long been held that a vessel is unseaworthy if a prudent owner, knowing of the defect, would have required it to be cured before the voyage commenced. I held that in 2011, when the incident occurred, a prudent owner would not have permitted the voyage to commence without a sound passage plan. The vessel was therefore unseaworthy. To discuss this decision and its ramifications, we have a most knowledgeable panel. We were to have had the benefit of John Russell, Queen's Counsel, who was the successful leading counsel for the cargo interests in the case. He not only persuaded me that the cargo interest should succeed, but happily, he fended off all the attacks made on that decision in the Court of Appeal and in the Supreme Court. Unfortunately, the demands of another arbitration have required his presence elsewhere this evening. But in his place, I am delighted to say that we have Ben Coffer, who was his junior in the Libra case in the Court of Appeal and in the Supreme Court. Like all good juniors, he will have supplied his leader with the points which enabled him to uphold my decision. And so I have no doubt that he will be able to give you a most knowledgeable introduction to the issues raised by the case. The international group of P&I clubs intervened in the Libra case at the leave stage in the Supreme Court and made their concerns about the decision clear. I understand that the international group also wished to present arguments on the appeal itself, but were not permitted to do so, since the very same arguments would be presented by the owners. Their desire to do so, however, demonstrates their concerns about the decision. David Richards is a director of the North of England P&I Club with particular responsibility for cargo claims, and was formerly a partner at Inson&Co, and for 3 years headed their team in Japan. He is very familiar with the concerns of owners and P&I clubs about the decision, and I very much look forward to hearing his perspective of the decision. In one sense, the decision in the Libra is already out of date. The case concerned traditional paper charts. Electronic charts are now in use, and the decision has now to be understood in that modern context. Peter Thornton, MBE, is a master mariner and a solicitor at Hill Dickinson. He was at sea for over 20 years. He has experience of paperless navigation at sea and has authored a work entitled The Actus Manual. He has also had a somewhat exotic experience of skippering a large racing yacht in the Clipper Round the World race. There can, I think, be no better person to explain to us how the decision in the Libra might be applied in the new context of electronic charts. There is little for me to say about the decision in the Libra which I did not say at first instance. Whilst I sought to apply well-established principles, there is no doubt that their application in the area of passage planning was novel. That can be illustrated by a comparison between the Libra and the case of Rio Tinto Company against the Seed Company, which was referred to in my decision in the context of the defense based on deviation. In that case, a vessel left her berth on the Clyde on Christmas Day, 1924, bound for Spain with a cargo of coal and coke. A pilot was on board for the passage through the Clyde. It appears that the master and pilot, and perhaps other officers, enjoyed a Christmas Day lunch of goose and plum pudding. Before the pilot left, he advised the master that the course to be steered was south-southwesterly. But after lunch, the master instructed the navigating officer to proceed on a south-southeasterly course. This led the vessel towards Troon Rock, on which she grounded and became a total loss. It was alleged that the vessel was unseaworthy by reason of the master being unable to navigate either through incompetence or illness. As it was put by counsel, the course was so extraordinary that it was compatible only with utter incompetence or something wrong with his brain. That defense failed, as did other defenses, including the defense of deviation. With regard to that defense, it was held that the master, quote, did not adopt another road instead of the road that he had agreed to take, but he got himself into the ditch at the side of the road which he was intending to follow. He was not on another route, he was on the existing route, although he was out of the proper part of the route which he ought to have followed. There was, however, no argument addressed to the court that the vessel was unseaworthy because there was no passage plan, or because the south-southwesterly course had not been laid off on the chart prior to the commencement of the voyage. So what had changed between 1926 and 2019 when the Libra was decided, and it was held that the vessel was unseaworthy because her passage plan was defective, because it did not warn the navigating officer of the dangers outside the buoyed channel. The terms of the contract of carriage in both cases were essentially the same. In neither case had there been an adequate passage plan. Indeed, in the 1924 case, it seems likely that there'd been no passage plan at all, and no course had been laid off on the chart. Of course, what had changed between the two decisions was the recognition in the latter part of the 20th century that safe navigation required the making of a passage plan before the voyage commenced. In 1999, the International Maritime Organization decided that voyage or passage planning, which had previously only been required by vessels carrying dangerous cargoes, should apply to all ships engaged in international voyages. IMO said that a well-planned voyage was of essential importance for safety of life at sea, safety of navigation, and protection of the marine environment. Thus, it was obvious, as it appeared to me, that any responsible owner would now insist on that, and thus it was that the preparation of an adequate passage plan became a necessary part of a vessel being seaworthy for the coming voyage. The case illustrates that although the language of the seaworthiness obligation remains the same, its content can be enlarged as more is understood with regard not only to the building and equipping of ships, but also as to what is required to promote safe navigation. In that sense, the decision illustrates that the seaworthiness obligation can move with the times. That, I would venture to suggest, is good law and promotes safe navigation. And with that introduction to the case, may I ask Ben Coffer to give us the benefit of his knowledge of the case.
Thank you. Well, as we've heard, the case arose out of the grounding of a container ship. The vessel was leaving the port of Jammen, and shortly after leaving port, she grounded on an uncharted shoal outside the fairway. The owners claimed general average contributions from the cargo interests. And as I'm sure everybody knows, under the Hague Rules, errors in navigation are accepted by virtue of Article 4.2a. But Article 3.1 imposes an obligation on the owners to exercise due diligence to make the ship seaworthy before and at the commencement of the voyage. And there are two important points about Article 3.1. Firstly, it's an overriding obligation. So that means the carrier cannot rely on the defences in Article 4.2 of the rules, where there's a causative breach of Article 3.1. And secondly, it's a non-delegable obligation. So the owners are liable for failure to exercise due diligence by any person to whom they delegate the task of making the ship seaworthy. So the issue at trial, as it often is in these GA cases, was essentially, was this just an error in the navigation of the ship, or was it caused by a failure to exercise due diligence to make the ship seaworthy? The cargo interests put forward quite a few allegations of unseaworthiness. I don't want to say scattergun, because Mr. Russell's not here to defend himself, but we might say something like comprehensive in their pleading. And only one of those allegations was ultimately upheld, and that was the allegation relating to the passage plan. you can now see a copy of a reconstruction of the vessel's working chart, which was helpfully annexed to the first instance judgment by Mr. Justice Teare. The purple lines represent the buoyed fairway, and there was a notice to mariners in force at the time, which warned that numerous depths less than the charted exist within and in the approaches to Jamen Gap. And it was held that as part of the passage planning process, that warning should have been translated onto the working chart. One way of doing that would have been to mark the areas outside of the channel as no-go areas, and it was suggested that that could be done with hatched pencil lines on the chart. Or an alternative would have been to write the warning on the chart itself. So to write on the chart some form of wording equivalent to numerous depths less than the charted exists within and then the approaches to Jamen Gap. And it was held that in the absence of that warning, or either as the hatched lines marking no-go areas or the warning itself, the chart was defective. The green line was the planned course through the fairway, and the red line is the vessel's actual course. And you should hopefully be able to see that there was a striking alteration of course to starboard about halfway through the course, which is shown on the page. The aim of that alteration was apparently to avoid a danger area marked in yellow, the larger of the two yellow circles. But that alteration took the vessel away from the fairway and away from the planned course. And it was held to be a negligent decision, and undoubtedly a navigational one. The vessel grounded where the red line stops, and right at the bottom of the page. And as you can see, there are charted depths around the grounding location of more than 30 meters. So it would have appeared to the master that there was plenty of depth there for him. But it was held that if the warning had been marked on the chart, the master was unlikely to have left the fairway. And so on those facts, Mr. Justice Teare held that the defective passage plan had made the ship unseaworthy, and that the defect in the passage plan was a consequence of a failure to exercise due diligence by the crew, and owners were liable for the crew's failure because they had delegated the task of preparing the passage plan to the crew. And at the risk of falling into the trap that Richard describes in his introduction, that looks like a relatively simple application of orthodox principles to an unusual set of facts. So why did it end up in the Supreme Court? Well, the owners argued that for a ship to be unseaworthy, there has to be a defect in an attribute of the ship. And they relied primarily in support of that argument on a case called the Actus, where cargo in the ship's holds was on fire. And the Court of Appeal held that just because the cargo is on fire, the ship is not unseaworthy. And they said that the fact of containing cargo which is on fire is not an attribute of the ship, and therefore is not capable, as a matter of law, of making the ship unseaworthy. Now, that is difficult to reconcile with the approach in more recent dangerous cargo cases like the Kapitan Sakharov, where the presence of one dangerous cargo which causes damage to other cargoes on board the ship has been held to make a ship unseaworthy. And it's difficult to see why there should be any principal difference between those two situations. And we said in the Court of Appeal in the Supreme Court that they were inconsistent and irreconcilable. So the owners said there has to be a defect in an attribute of the ship, and a passage plan can never be an attribute of the ship. It's just a record of navigational decisions. But the difficulty with that is that the range of defects which have been held to amount to unseaworthiness in English case law is very wide. And in particular, it is generally accepted that a defective chart can constitute unseaworthiness, although it's surprisingly difficult to find a clear authority for that proposition, or at least it was until Teare. So the owner said, well, yes, a chart, defective chart can be unseaworthiness, but a passage plan is different from a chart, is categorically different, because passage planning is an act of navigating, and the nature of that act doesn't change when you write it down. But you can see why there's a difficulty with that when, in a situation like this, passage planning involves adding markings to the chart. So if the chart being defective can make the ship unseaworthy, and everyone agrees with that, then it's difficult to see why making changes to a chart shouldn't make the ship unseaworthy. And the owners also said, as a sort of fallback argument, that even if the vessel was unseaworthy, it wasn't the consequence of a failure to exercise due diligence on the part of the owners. They said an error of navigation can never be a failure to exercise due diligence for purposes of Article 3.1, because although the owner's obligation is a non-delegable one, there are some matters which just fall completely outside the scope of the owner's responsibility. And that proposition is correct to some degree. There are two recognized categories of cases where matters do fall outside of the owner's responsibility. One, the sort of most famous example is shipbuilding cases. So the owners are not typically responsible for failures to exercise due diligence by ship. The person's building the ship before the ship comes into the owner's orbit. And also dangerous cargo cases. So some of the more recent dangerous cargo cases have analysed the presence of dangerous cargo as making the ship unseaworthy, but not giving rise to a liability on the part of the owners, because the relevant failure to exercise due diligence takes place outside of the owner's responsibility. It's a failure to exercise due diligence by the cargo interests in relation to the preparation, production, custody of the cargo before it gets anywhere near the ship. So there is a limit on the owner's responsibility and on the non-delegable nature of the Article 3.1 obligation. And the owner said there's a third category of cases, which is where the failure to exercise due diligence is in navigating, and navigational acts, or the act of navigating, is not within the owner's orbit of responsibility, just like shipbuilding isn't within the owner's orbit, or preparing dangerous cargo for carriage is not within the owner's orbit. Now, that actually, to my surprise, does seem to be the approach which is taken in some US cases. So there was some reasonably low-level analysis of the position in the US in the Supreme Court. And I think the Supreme Court wasn't terribly interested in it because it's quite difficult to piece together from one or two cases here or there what the position is in a foreign jurisdiction if you're trying to do it by submission. And I think it's fair to say the US cases don't speak with one voice, but there are definitely some US cases where that does seem to be the analysis. So the US courts do seem to say sometimes that acts of navigating which fall within the Article 4.2a defence are just not capable of being failures to exercise due diligence to make the ship unseaworthy, make the ship seaworthy. But it's not the law in England. So in England, there's a Court of Appeal case, the FJ, where the ship has insufficient fuel because of the master's error in calculating the ship's route. That is a navigational decision, undoubtedly, and it has the effect of making the ship unseaworthy. So in England, it's clear that navigational decisions can make a ship unseaworthy. And of course, Article 4.2a is not just errors of navigation, it's also errors of management. And there are a lot of cases in English law where errors in the management of the ship have been held to make a ship unseaworthy. So whatever might be the position in the US, in English law, it's pretty clear. So the Court of Appeal and the Supreme Court rejected the owner's arguments, essentially for the same reasons, and the reasons were pretty much the same as the reasons given by Sir Nigel. The courts held that there is no rule of law that there has to be a defect in an attribute of the ship. So the apostolis to that extent was wrong. Navigation is not in some sort of special category of acts which cannot make a ship unseaworthy. And the orbit principle doesn't apply to acts of navigation. So in most cases, you just have to ask, would a prudent ship owner have sent the ship to sea knowing of the defect? Although there might be some cases where that test is not appropriate, and that's a sort of possibility tantalizingly left open by Lord Hamlin at the end of his judgment. He says there might be some circumstances where the prudent ship owner test is not the be all and end all. But there's no real discussion as to what those sorts of cases might be. The only clue is that the case he has in mind is the Actus, which is a case where, on the facts, a prudent ship owner probably wouldn't have sent the ship to sea, but not for reasons which were anything to do with safety. So it looks as though there might be a sort of safety requirement, that seaworthiness always has to do with the safety of the ship or the cargo. And that comes in potentially at the sort of latest stage of the analysis. So I'll hand over to David now to explain it from the owner's point of view and why everything I said as well.
Following on from that, I intend to look at how this decision is seen by our members and what we as a club have seen in terms of impact. I think the first thing to bear in mind is that Sir Nigel's judgment was issued in March 2019, and it hasn't been substantially revised on appeal. So we have been living with this decision for now almost 3 years. And so we have a good idea now about its impact. The decision of the Supreme Court, of course, is more recent. And we find there, I think, some helpful clarifications about the law in the area of unseaworthiness, which Ben has already talked about and which I will look at from the P&I perspective. But first, I'd like to reflect on some of the defences to the GA claim that were raised by cargo, which didn't concern passage planning. Incompetence of the master, inadequate bridge management, fatigue, and deviation. And I think that with the exception of deviation, these are all, in my experience, fairly frequent reasons given to try to resist contributing in GA. And in this decision, those arguments were dismissed. And in particular, even though the negligence of the master during the voyage, so not his passage planning, but his negligence in leaving the fairway, even though that seems to me to be fairly egregious, the master's 30 years of seagoing experience, 16 years with these owners, 8 years in command, and his the decision to appoint him to a new build vessel all seem to have protected him from a finding of incompetence. Equally, the bridge team management and the fatigue arguments were fairly shortly dealt with. So in terms of this decision, there's some comfort to be taken there for owners. The deviation argument was, with respect, somewhat more eye-raising, given that this was an argument that Sir Nigel has spoken about it in his introduction, that the decision to deliberately depart from the fairway, even by a very small amount, meant, said cargo, that this was a deviation from the contractual route, and therefore the owner had lost all the benefit of their defences. An argument which, if it had been successful, had the potential to deprive the owners of their cover. Fortunately, then, that argument was also dismissed, and we now have a fairly useful statement in Sir Nigel's judgment about deviations being about radical changes in the voyage and not simply going out of the way. So what we now have is a final decision from the Supreme Court to the effect that serious defects in the appraisal and planning stages of passage planning are capable of rendering a ship unseaworthy. And the immediate consequence of this for us as a club is we do see an increase in cargo claims, GA defences, which allege, amongst other things, inadequate passage planning. It becomes fairly routine. But many of those allegations are baseless when the passage plan is reviewed by the experts. But on the handful of cases we see in a year where we do see a serious pre-voyage defect in passage planning, then the critical question in our experience, and this is what we're routinely advised, is the question, was that defect causative of the loss? And in many cases, the defect relates to poor implementation of a passage plan and therefore wasn't pre-voyage, or equally the negligent changes to an adequate passage plan. And again, there, the Libra decision seems to have no relevance. So it's again a smaller category of cases where it's really troubling. And when people discuss the Libra, I often hear them say that they really can't understand this master's decision making. And what the first instance judgment tells us is that 3 days after the grounding, the master said in a witness statement that he was concerned he was approaching an area of shallow water, but he thought there was, quote, plenty of water to port outside the buoyed fairway. So he intentionally decided to depart the fairway and then he planned to rejoin. So this wasn't a case where the master, for example, just lost positional awareness or lost navigational control of his ship. And it seems to me that the master's explanation that he made a deliberate decision to leave the fairway was critical to that finding, that if the presence of depths less than charted outside the fairway had been noted on the chart, then the master would not have taken that decision. And it seems to me that in other cases, if you apply almost exactly the same facts, but the master didn't deliberately decide to do this, he just sort of lost his way, then the causative relevance of a defective passage plan seems to me much more doubtful. On the attribute of the ship test, as Ben has explained, it was a focus of the owner's arguments on appeal that there were previous authorities which had said, it seemed to be in pretty stark terms, that unseaworthiness must come from an attribute of the ship. The Apostolis, which Ben has referred to, says, quote, for a ship to be unseaworthy, there must be some attribute of the ship itself which threatens the safety of the cargo. And my understanding for this case would have been similar. One always used to think of seaworthiness as really being about the ship itself or some systemic issue with the ship. But we now know that pre-voyage decision-making can come within that. And I think that is fairly new. But the Supreme Court didn't do away with the attribute question entirely, it seems. They said that the attribute threshold is, if it exists, widely and diversely drawn by looking at previous cases, and could still be used as an illustrative rather than a prescriptive requirement to test the question, was the vessel unseaworthy? So we may not have seen the end of the attribute test quite yet. The other point touched on by the Supreme Court, as I read it, is this prudent owner test. And just at the risk of repetition, to look at that again, that is the test whereby one asks the question, would a prudent owner have required that a defect be made good before sending his ship to sea had he known of it? And the words had he known of it seem to be critical, because the question is not whether this ship owner actually knew of a defect and had failed to deal with it. It seems to be a test of some all-seeing, all-knowing ship owner who is told about a problem and has to sit there sort of pipe in hand and decide, will I fix this or not? The problem with this test, practically speaking, is that when a defect manifests itself and causes some serious cargo loss, when you ask your advising lawyer or expert master mariner or ship management expert the question, well, if you'd known about this, would you have fixed it? The easy answer is invariably, well, of course I would have. it is practically speaking a test which is, I'd suggest, only too capable of returning one answer from the position of hindsight where you know a serious loss has occurred to say, well, yes, I would have put that right. And so invariably, people say, well, the ship was technically unseaworthy, we'd better focus on due diligence arguments. And that is another area where this decision may be slightly surprising, in that the problem was it was axiomatic that because it was pre-voyage negligence which had rendered the vessel unseaworthy, there would seem to be no stage 2 due diligence defence, because one just followed from the other. And you know, I think Ben has already mentioned this, but applying that test to the Aquacharm, the ship is overloaded. The court says it's not unseaworthy, but a prudent owner wouldn't have allowed that ship to set sail if they'd known it was overloaded. And so what the Supreme Court said is that the prudent owner test was helpful and well suited to deal with evolving standards in the industry, but not a universal test. And they said that in appropriate questions, a more fundamental question would be to ask whether the defect or state of affairs relied upon was sufficient to affect the fitness of the vessel to carry the cargo safely on the contractual voyage. Now, Lord Hamblin thought that this prior question might only arise in what he called cases at the boundaries of seaworthiness, but it seems to me that it's more fundamental than that, and that really it's a question that should be asked in all seaworthiness cases. Is the defect sufficiently serious to affect the fitness of the vessel? Remembering that seaworthiness is an irreducible obligation. You can't contract out of it when the rules apply by force of law. You're stuck with it. It doesn't matter whether you want to carry cargo for $1 from one side of the world to the other. You're stuck with this obligation. And so it's fair to ask, when you're looking at whether it's breached or not, whether you're really looking at danger to ship and cargo. I think Lord Hamblin summed it up very well in one particular paragraph of his judgment, where he was looking at, he headed it insurance risk. And hopefully it's on the screen now. He said at paragraph 82, in relation to the balance of insurance risk, which is what I deal with, ship owners and their insurers bear the risk of cargo damage or general average expenses caused by a failure to exercise due diligence to make the vessel seaworthy. That remains the case where unseaworthiness is caused by negligent management or navigation. But you know, the part that I will be underlining is that most negligent navigation will occur during the voyage rather than before it. And so it is correct that the main burden of resulting cargo damage or general average claims is likely to fall on cargo owners and their insurers rather than ship owners and their P&I clubs. And it may be, as owners submitted, that a decision that negligent passage planning may render the vessel unseaworthy will lead to more cargo damage or general average claims being made against ship owners and their clubs. However, it's necessary to prove first that the defect was sufficiently serious to render the vessel unseaworthy, and secondly, that it is causative of the loss or damage. So again, I think that's quite important from the Supreme Court to bear in mind the emphasis on serious defects and causation. And just to conclude, a few other useful comments that I thought from the Supreme Court judgment in relation to seaworthiness generally. The first is that the Supreme Court reminds us that the duty is to provide a seaworthy vessel is not equivalent to a duty to provide a perfect ship. So again, it's serious defects that one is concerned with. And the last point is the point that Ben has already mentioned, the orbit, which is that an owner is not responsible for the negligence before the ship and the cargo comes into its custody and control. So that seems to me to involve 2 points in time. The carrier is not responsible before the ship comes into its custody and control, or before the cargo comes into its custody and control, unless after that point in time the defect was reasonably discoverable. And finally, there's also a reiteration that a ship is not unseaworthy if an owner could reasonably expect to remedy a defect before danger to the ship or cargo arises. So in summary, a useful clarification on this area, something that I'm sure in the long run will help resolve disputes between owner interests and cargo interests more readily, but one which maybe arose on quite peculiar facts on causation, and which we'll have to see whether it has as big an impact as has been suggested. Thank you very much.
Well, good evening, everyone. As the intros have already been dealt with, I'm going to crack straight on with giving you an insight into how the mariner deals with passage planning, and in particular, a temporary and preliminary notice to mariners, which was critical to the CMA CGM Libra case. Now, I've been asked to do this in order to appreciate the processes and differences that are involved between the paper chart and Actus navigation. And this is in order to try and answer the question of whether the Libra decisions have already been superseded by the adoption of Actus as the primary method of navigating. So I've got a few slides to show that I'm going to share my screen. So in so doing, I'm going to give you a quick intro into the navigational warning that was missed by the Libra, and then how it could have been managed on the paper chart so as to not result in a defective passage plan. Then how the mariner deals with the same issue using an Actus before finishing off with considering whether the Libra has been superseded by the adoption of Actus navigation. So the crux of the Libra case was the failure to apply this preliminary notice to mariners to the paper chart during the planning stage, which subsequently led to the vessel using a chart that did not adequately show all of the information that was available, and the master making a decision based on a defective passage plan. So in considering why the passage plan was defective, it is useful to understand exactly what a notice to mariner is, and in particular, a temporary and preliminary notice to mariner. Well, firstly, a notice to mariner is information that the appropriate hydrographic office of the chart has deemed important enough to be promulgated, so that the mariner is required to make a change to the nautical publication or chart that it affects. Now, the majority of these changes are permanent and as such are changed in pen. However, some notice to mariners are in fact temporary or preliminary and can be overlooked, which is what the Libra case is about. So a temporary and preliminary notice to mariner, or TMP for short, is information that is not suitable for permanently changing a chart, so any correction ought to be made in pencil. But the annotation on the chart should be sufficient to alert the mariner to the danger in order to conduct proper planning and therefore execution. Now, TMPs can either be a temporary notice, which is valid only for a certain amount of time, for example, a scientific buoy that is only on location for a number of months, or it could be a preliminary notice, which could be a warning that depths shallower than charted have been reported, but full details are not yet known. Well, this is what the Libra situation was about. So, save for my red pen, unfortunately, I've used the black and white image that was available from the Lloyd's reports. So, save for my red pen, which I've used as an example. This is the chart extract taken from the case report that I could obtain at the time. Now, I won't go into the navigation detail here as the chart resolution is not particularly clear, but you've already been described how the Libra's route was down this fairway, this line that is in between the two red lines, and then Libra's track is this curved black line that leads down into the bottom of the chart where Libra grounded in this location. Now, as Ben has already described, judging just or using or referencing just the hydrographic bathymetric safety contour, or the contours that are on the chart, there should have been enough water to navigate through here. Now, unfortunately, there wasn't, which was information that was contained in the notice to mariner that was not applied. Now, of course, it's already been mentioned what that warning was, but for ease of reference, it was numerous depths less than the charted exist within and in the approaches to Jiaoman. It also mentioned that the most significant were identified, but none were in the fairway, and it went on to say that the fairway had a least depth of 14 meters. So given that it's now been accepted that the fairway was that as marked here by the two long red lines, what should have been done with that information? Now, the generally accepted method is that these areas outside of the fairway could have been hatched out, as shown here, but of course in pencil, because it's a preliminary notice to mariner, and with a note explaining why they were a no-go area, just to avoid any confusion. However, that was then with a paper chart. So what about Actus navigation? Well, there are two parts to that we need to understand in relation to applying such a warning as a TMP to an Actus. The first part is knowing the electronic navigational chart itself and what it holds. And then the second part is knowing what to do with the Actus in order to see the warning, in order to take it into account. Now, firstly, with regard to part one, the ENC itself, not all countries include the temporary and preliminary warnings in their ENC updates. Now, by way of an example, this is an extract of a list showing 75 countries ENCs that are available through the UKHO's Admiralty Vector Chart Service. Now, of which most do include the temporary and preliminary notice to mariners within their ENC updates that are issued weekly. But importantly, 21 countries do not include their TMPs within their ENC updates. Now, this means for the navigator navigating in those waters that do not have TMP notices as standard, they need to source their TMP information from elsewhere. But before I move on from this page, and given the subject of this discussion and the area that we're dealing with, you may have noticed that China is one of the countries that does not include TMPs on their ENC updates as standard. And it is also of interest that some of the other countries that cannot be seen on this slide and further down the list that also do not include TMPs as standard are the USA, India, Greece, and the Malacca and Singapore Straits, which are all some pretty busy shipping areas. However, for the mariner navigating waters whose ENCs are updated with TMPs, this is what they may look like. Basically, it's the same as a permanent notice to mariner, save for the important aspect of date-dependent objects, which will only show up when within the date range, which means setting the date correctly for passage planning is important. And for waters where countries do not include temporary and preliminary notices within their ENC updates, the vessel's chart provider may provide overlays, for example, the Admiralty Information Overlay. So the Admiralty Information Overlay is an Actus compliant overlay that shows TMP warnings by way of an area with the details available by interrogating that area, which is known as a PIC report. And then finally, for those mariners that don't subscribe to such a service, the mariner needs to revert to obtaining the TMP from either the paper publication or online and applying it manually using the Actus drawing tools, which is just the same way as if using paper charts. Which leads me nicely on to part two of managing warnings, the Actus software and user settings. So part two is knowing the Actus software you're operating with and the Actus user settings that are applied. This list here shows a number of ECDIS manufacturers. There are in fact approximately 44 ECDIS manufacturers out there now, each with its own look and feel for the mariner to get used to, which sounds quite daunting, but they are all designed and type approved to the IMO performance standards, which does mean that they must all be capable of displaying the E&C corrections. So as a basis, that's all good to start with. Having said that, I do need to mention that the ECDIS still needs to be updated from time to time. That is with the latest IHO ECDIS symbol library, presentation library. Now this often requires a manufacturer's software upgrade. Now the last was issued in 2017, version 4, so most ECDISs should now be updated, but it is certainly something that carriers, owners, and mariners need to be aware of, as without the latest IHO symbol libraries installed into the ECDIS will not be able to show all the objects as required, and therefore may not meet the SOLAS criteria to satisfy as a replacement for paper charts. So then, once the ECDIS software is up to date, there are the ECDIS user settings. Out here, whether the T's and P's are incorporated into the E&C update or shown up as an additional layer, as in the AIO, the navigator still needs to set the ECDIS up correctly. This is to ensure that they can either see them while laying off a new route or be alerted to them through automatic route scanning. By way of example, top right up here, the date dependent object that I mentioned earlier, when planning the passage, the navigator now needs to input the correct date in order for those date dependent objects to be either visible or be taken into account with the automatic route scan. Top left is if the mariner is in waters where an AIO is needed, i.e. T's and P's are not included, and this AIO layer must be turned on in the first place to be visible and taken into account. The bottom two images here I've just included by way of a quick example to show that the scale of display that the mariner is using is also important, because if you're not viewing the chart at the optimum scale, then the object may not be seen, and that applies to the route scan as well if that's not been set up correctly. So this is pretty similar to choosing the larger scale paper chart to plan with. And then lastly, as mentioned before, the mariner may still need to manually input warnings or dangers in order for them to be clear and taken into account during planning and then execution. And this ability to draw lines on an ECDIS is part and parcel of being able to clearly delineate where a vessel's safe water is, especially if one of the main safety contours is not suitable for voyage safety depth. And this is my final slide. I'm sure you'll be pleased to hear, but this is just a quick example of a basic passage plan where I have highlighted certain dangers that lie outside of the closest ECDIS safety contour. So the closest ECDIS safety contour is this dark blue shaded area, and the highlighted certain areas, for example, here by using a red hashed area, and also a mariner's inputted safety no-go line. Both of which can be alarmed. So this way, a vessel's safe water can be clearly seen, and if the vessel needs to depart from the auto-scanned, suitably wide cross-track corridor that is now capable of being displayed and used on an ECDIS, the mariner knows where the safe water is outside of that cross-track corridor. However, of course, to do all this, the information first needs to be extracted and then displayed on the ECDIS, which is certainly a change in mariner skill set and not the same as a mariner being able to see all of the information on a paper chart as they were before. So to conclude, has the Libra decision been superseded by ECDIS? So really to conclude, has the Libra decision been superseded by ECDIS? I would say no, not yet. Using an ECDIS does mean that most hydrographic organizations or hydrographic offices corrections will be applied automatically once the update disk has been loaded, but that doesn't happen in all parts of the world yet. So using an ECDIS certainly also means that most dangers, if part of the E&C, are likely to be picked up by the automatic route scan, but this is only within the cross-track corridor set by the mariner, and only if the user settings are applied correctly. And all of this is part of passage planning. And that still doesn't include all of the other navigational warnings and information from the likes of the sailing directions, nav text, and local port warnings that all should be taken into account. Managing this information is generally just the same as using a paper chart. So in my opinion, if the mariner does not pull the warnings out of the ECDIS and other publications and plan accordingly, it is no different to a mariner failing to pull the warning out of a paper notice to mariner and add it to a paper chart sufficiently to take it into account when planning. So that concludes my presentation, and I'll now hand back to the panel. This is certainly a lot that can be discussed with regards to carriers being confident that their vessel's passage plan is adequate for safe navigation. The success of the latter certainly very dependent upon the quality of the former. Thank you very much.
Thank you very much, Peter. We will now see what questions have been asked. Could I just begin by asking a question of you, Peter? Having regard to the facts of the Libra, if those facts had taken place in the context of electronic charts, and if the chart was one of those which did not include temporary notices to mariners, what notice, in your view, would the mariner place on the electronic chart to inform the navigating officer of the danger? Would he use a form of hatching? Would he simply write a note on the chart, or what?
Well, thanks, Nigel, for the question. I'm just going to actually go back to the slide that showed the particular chart in question with regards to the Libra, which might be easier to show what I believe would have been shown. So it wouldn't be too dissimilar to this. The red lines indicating, the red long lines indicating the fairway would essentially be very similar by way of the cross-track corridor. So that's the corridor that the ECDIS would automatically scan. And then outside of that cross-track corridor, the mariner has an option either to certainly make sure on the passage plan details that it's been informed not to leave the cross-track corridor because it's dangerous. And on the actual ECDIS screen itself, there's no reason why a note such as this cannot be inputted onto the ECDIS screen at all scales, whatever level of zoom they're looking at, in order for it to be obvious that that is why they should not leave the cross-track corridor.
Thank you very much. Thank you. One of the questions which has been asked is whether the decision in the CMA Libra is a signal to the owners that the scope of their protection under Article 4, Rule 2A of the Hague Rules, that is the negligent navigation exception, has been narrowed down. Ben, I wonder, could you respond to that question, please?
Sure. Well, from my perspective, I would say the answer is no, because as I understand the decisions, they do no more than state what the law has always been. I suspect David might see it slightly differently, but we have been, John and I have been around speaking to people about the decision since it came out. And there does seem to be a perception in the market that this is part of a growing trend of sort of pro-cargo, anti-owners decisions. But it doesn't feel that way to me. To me, this feels like, as I say, an orthodox application of the existing principles to a slightly unusual or new set of facts. But it'd be interesting to know what David thinks about that, whether he agrees.
Well, I think you're right about the perception. Certainly, one of our members said to me, why do judges hate ship owners? And it certainly feels that way sometimes. I struggle to think of a happy decision made recently, but I think things are often approached back to front, in that if you have a case like a grounding where there's been a negligent navigational decision, you would start by thinking, well, that is an accepted peril. Normally, a straightforward grounding case like this, you would think, well, the division is that is not something for which the owner is responsible, and it's afterwards that you then get the shock of saying, well, I'm afraid that's not the way the law sees it, and your vessel was unseaworthy. So I can totally understand why owners feel that this does erode their protections, which they thought were carved out under the Hague rules. But I entirely accept what you say, that legally speaking, there have been many decisions where things which look like navigational decisions have crossed the line into unseaworthiness. And I think the more important thing to bear in mind is that is to make sure that we focus on where the bar is for unseaworthiness, and resist the trend that almost anything, almost like US limitation cases, almost anything crosses the line into unseaworthiness these days. I think that's what's important to resist.
Thank you. Another question, a rather different point, which has been asked is this: the decision in the Libra relates to a cargo carrying merchant ship, but SOLAS applies the requirement for an adequate passage plan to all vessels and requires all, even small craft, to have some form of passage plan. Do the panel feel that an inadequate or total lack of some form of passage plan would extend the consequences of the Libra decision to all craft, even, for example, commercial fishing boats and leisure craft? It seems to me that if seaworthiness is relevant in the context of commercial fishing boats or leisure craft, it would have to be relevant in some slightly different context, because the Hague rules are unlikely to apply to those craft. But if it did apply, then there is no reason why it shouldn't also apply to such craft, since IMO, overseeing the introduction of SOLAS, considers that it should apply to such craft. But of course, what would amount to an adequate passage plan will very much be dependent on the purpose of the particular voyage and what the craft involved is doing. And it may be that what is appropriate as a passage plan to a cargo carrying merchant ship would not be appropriate in the different context of commercial fishing boats or leisure craft. I don't know whether any other members of the panel can add to that answer.
I suppose certainly I would agree that from a cargo claim point of view, that's not going to have much relevance to a commercial fishing boat or a leisure craft. Different forms of marine insurance might apply, and seaworthiness, of course, originally was a marine insurance concept, a warranty that your vessel would be seaworthy. And it may be that under policies for fishing boats north through a different part of the business insures fishing boats, it might be they're more likely to breach a warranty. And of course, the fishing boats and leisure crafts, they're often operated by the people that own them. So they've got more trouble potentially with an alter ego argument, in that if you don't have a passage plan at all, then that's something which the operator of the fishing boat, who's also the owner, that they might have well known that their vessel was not seaworthy. So that could cause a problem there.
Thank you. And a third question, again, a very different type of question, is this: slightly beside the point, but why were the chartered debts in the Libra incorrect in this case? Again, I don't know whether Ben can recall the reason for that. My own recollection is that the data on the Chinese chart originated from local Chinese surveys, and they were of some antiquity, and there hadn't been very many recent surveys, but I don't know whether Ben can add to that.
I just have in mind that there was a minefield, and that was one of the reasons why there haven't been recent bathymetric surveys.
Yes, yes. Well, I think those are all the questions which have been raised. Perhaps I should just sum up with one or two closing points. Firstly, if the decision is regarded by some as a surprise, I think for the reasons given by David Richards, speaking from the club's perspective, it is important to remember that causation is and always will be an important limitation on the defense being successful. The other point which seems to me to be of significance is the emphasis which was placed by David Richards on the observation by Lord Hamblin, or the phrase he used, namely whether the defect is, quote, sufficiently serious, unquote, to make the vessel unseaworthy. That gives rise to the possibility of a spectrum of seriousness in the categorization of defects, and that might be scope for elucidation in future cases. And the final point I would make concerns now the presence or the use of Actus. It seems from Peter Thornton's very clear exposition of Actus and how it works and what the mariner has to do, that the principles of passage planning are unaffected. But I can foresee debates in the future as to precisely which of the various digital devices available to the mariner should have been used in the particular case to produce an adequate passage plan. One point which occurred to me was when Peter mentioned that it's essential for the mariner to use the electronic chart on an appropriate scale. And one can envisage circumstances where if too large a scale is used, a different picture would be presented to the navigating officer than if a very small scale were used. One has to remember that passage planning has been described by David Steele when he was the Admiralty judge as an art and not a science. And so there will be scope for debate, as indeed there was in the Libra, as to precisely what notations on the chart, whether it be paper or electronic, are appropriate in the particular case. And I can foresee debates of that nature in the future as well. So I hope that sums up some of the interesting points which have arisen in the course of this evening's interesting discussion. And may I therefore hand matters back to Richard.
Well, it only remains for me, on behalf of the London Shipping Law Centre and all the listeners this evening, warmly to thank our speakers and our chair for a truly illuminating discussion. There'll be many listening this evening who will themselves have given webinars in these strange days of COVID. And we all know just how much work is involved in putting on talks like this. So I'd like to thank you all very much indeed for having put in so much work into such illuminating speeches. For those listening, our next London Shipping Law Centre event is on the 24th of February, given in association with Holman Fenwick Willan, with the title of Ship Recycling. And so, therefore, I can simply say thank you to all, and I wish you all a very good evening. Good night.